This is an application and appeal in the matter of Kerish International Motors Agency and Opel Automobile GmBH.
Yes, Mr. Sinclair.
Yes, good morning, my lords. I appear for the appellant in this matter, Kima. My learned friend, Mr. Andrew George, KC, and Miss Drishti Suri appear for the respondent, Opel.
Yes.
My lords, there's a regrettably large number of documents floating around rather than in files, but can I just run through what we have just to make sure we have the same?
Yeah.
So there should be 4 files that were here last time we met, or most of us met. There's a core bundle, there should be a supplementary bundle, an authorities bundle, and then there was a very small additional bundle that was called the appellant's application dated 4th of June.
Yes, my authorities bundle's in 2 parts, but
yes, it's the same. Yes, I'm grateful. And then there have been a flurry of additional documents since then, which are not in particular bundles. Firstly, there's a supplementary skeleton from my learned friends.
Yes.
From 8th of June. Then there were 2 witness statements, an application notice, and a supplementary submission from my side on the 22nd of June. And then we had a witness statement and skeleton in response on remission from the respondent on the 26th of June. And then yesterday we had 2 translations of 2 of those documents.
Yes. And which of these various applications are live?
That's a good question, my lord. I would, as far as I'm aware, the application by the respondents to admit additional evidence has not, in fact, officially been withdrawn in any sense. My learned friend in his skeleton says, well, we don't think we need it anymore. So in a half-hearted sort of way. But we would.
Shall we find out? Is it pursued? Is it pursued, Mr.
To be
George?
half-hearted. We've made the decision we do not pursue that application, and my lords will have seen how the issues have arisen.
Right. Well, we had an application which is still live, I suppose, by way of a counter to his application as previously made.
It was contingent.
It said if his evidence is admitted, we wish to put this in response.
Yes,
so that falls away, doesn't it?
Well, there is a prior question. Sorry,
the reality is, Mr. Sinclair,
yes.
that the basis for remission to the judge has been cut away because Mr. George isn't pursuing his application.
Well,
so if you want to seek to remit to the judge, you're going to have to persuade us at some basis on which it should be remitted, rather than now dealing with the case on the basis of the evidence as it was before the judge.
Yes, my lord.
Which is what we normally do.
Yes, my lords, I accept that. But there's also a question, my lords, as to whether my learned friend is entitled to simply withdraw an application.
Why should he not be?
Well, in my submission, he made his application to admit additional evidence. We, in reliance on that, made a counter application, have proceeded until very recently to believe that he was still pursuing it. He has, in his most recent skeleton that was served on the 8th of June, he put forward an additional authority, the Court of Appeal decision in Palestine in Thorn, which he put into the bundle, and the skeleton that he lodged on the 8th of June relies on that judgment, not in any contingent way, but says that Court of Appeal judgment supports his client's case. So as far as we were aware, certainly possibly on the 26th of June he made clear he was withdrawing that application, but from his skeleton argument on the 8th of June relied on this additional Court of Appeal authority. And we have proceeded to respond to that and to prepare for this appeal on the basis that your lordships will be looking at that Court of Appeal decision. We agreed that that document should go in the bundle by consent. My learned friend's solicitors wrote to my solicitors in December last year, 9th of December. They said that they wanted to insert the Court of Appeal's decision into the bundle. They said, please confirm. We were asked to confirm our position, and if we didn't agree, they would make an application to admit it into the bundle. And would seek their costs from us. We agreed to that Court of Appeal decision going in the bundle. So that is a document that is in the bundle by consent of the parties. I would submit. So there's no application required to deal with that Court of Appeal decision.
Do you rely on that decision?
I do rely on that decision.
Thorn in the Court of Appeal?
Yes.
Supporting your case?
Yes.
Where's the expert evidence that
There's
says it
none.
supports your case?
That's why I asked for this matter to be remitted.
Fresh evidence for the moment. Do you seek to adduce that decision as fresh evidence?
Well,
The Court of Appeal decision.
if I must, but
no, not.
Well, I
if you
don't
must.
because
Do you?
well, I say it's already in the bundle. Well, if your lordship's not with me on that, then yes, I do. Yes, I
The
do.
court whether it's admitted
Well-
the evidence, and there has to be an application to admit it.
Well, is that right,
Even if
my
the
lords?
parties agree, it still has to be approved by the court.
Well, I'm not.
This court.
Well, my lords, there was a direction from my Lord Justice Popplewell last week or so that said, if the parties agreed, then this matter would be remitted. But if, as he took it, and as indeed we took it, they objected, then we would have to apply. But in my
I don't think that's quite what I said. I was anxious to find out whether remission was opposed or not.
Okay, well then I had misread that and I apologise. But in my submission, if the parties are agreed that a document, new evidence should go in the bundle, then it's in the bundle in my submission, and that the court therefore has that document. And
But you are pursuing, are you, an application to remit an issue
yes,
to the trial judge or
yes.
to a different judge? I'm not quite sure which.
Well, ideally the trial judge if he's available, but otherwise another judge.
And we must deal with that application, because if we grant it, we're not going to hear the appeal, presumably.
Correct.
And if we refuse it, we'll hear the appeal on the basis of the evidence that was before the judge.
Correct.
Right, well, you better make the application then.
Grateful, thank you. I will. And just to say, that I think we have time for this because this was down for 2 days on the basis that the one voice doctrine
Yes,
would
well,
need
that's
to be
gone.
resolved. Has gone away. So I think yes, I hope I can make this application in the full way without concern. So can I show your lordships the key documents that are the background to this? So the respondent's skeleton argument on the appeal is in the core bundle. It's at tab 6, page 80.
Page?
80. So this is the respondent's skeleton argument. At paragraph 4, the respondent said that they sought permission to rely on 2 recent decisions by the Palestinian court, which they said supported the judge's findings on Palestinian law. They said that they should be admitted for 2 cumulative reasons. Firstly, that the judgments were following Ladd and Marshall were not available at trial. Secondly, that they are important to the Palestinian law issues in the case. And thirdly, are authoritative. And then there was a secondary but cumulative position that if, contrary to their primary submission, the court decides it's appropriate to reconsider Palestinian law, the judgments are important evidence on Palestinian law, and the judgments are necessary material to conduct an assessment. And although my learned friends will say that that second part was conditional on his primary submission that your lordship shouldn't even look at Palestinian law, his first limb was not conditional. And second point to make is that the conditionality arises out of paragraph 3, where he sets out his the main principles, which is that issues of foreign law are questions of fact. That's 3.1, and he points out that he says the test is in 3.1. He says that the court cannot substitute the judge's findings unless I can establish that the findings were plainly wrong. But in order to establish whether the judge's position was plainly wrong, one has to look at the Palestinian law, what evidence there is. So even on his primary position, one looks to the Palestinian law. This court looks at the Palestinian law in some way to be discussed in how. and assesses whether or not the first judge got it plainly wrong. And so on any view, their case was that these two decisions, the first instance decisions at that stage, were important evidence and necessary material. And then, my lords, if we could pick up slightly later in the skeleton at paragraph 47, so at 47, they point out that the judge relied on live evidence, which this court doesn't have the benefit of, and repeats the plainly wrong test. And then at 49, my learned friend goes on to say, moreover, the judge's findings are supported by two recent Palestinian judgments. And he refers to the case of Thorne at 49.1 and 49.2, and the case of the Japan tobacco case. And he summarises what he takes from those cases. And then at paragraph 50, he says, it's generally acknowledged the appellate court will restrict itself to the evidence before the trial judge. However, it's submitted the court should exercise its discretion to admit them for the following reasons. He goes through the stages of Ladd and Marshall in the next three paragraphs. So 50.2, again, he says that the decisions would have been important to the judge. And at paragraph 50.4, he says, in any event, the admission of the Palestinian judgments at this stage will further the overriding objective of dealing with the cases justly. It will ensure that the court has all available evidence to evaluate the judge's findings. This is particularly crucial, I underline, in a case such as this, where the various factors he identifies. So the position he put forward at that stage was that these first instance decisions were important and indeed crucial. And I would observe that this section of his skeleton is not in any way contingent on the question of whether or not your lordships look at Palestinian law at all. It was a pure observation that these were important stroke crucial decisions. And then, my lords, if we could look at the application that they made, which is in the supplemental bundle. At tab 11.
I don't have tabs. Could you give me a page?
The page is 285. This was the witness statement to my learned friend's instructing solicitor. And if your lordships would please turn to paragraph 10. Well, and 9, he refers to the evidence that they wish to admit, which is the first instance decisions in Thorne and Japan tobacco. Then he runs through the Ladd and Marshall tests again at paragraph 10, including the observation again in section B that the judgments would have had an important, albeit not decisive, influence on the case.
I think it's more accurate to say, which may be important, that the application is in relation to Mr. Atera's report exhibiting those decisions, because as we know, we don't just look at foreign law decisions and make our own mind up about them.
Yes,
That may be relevant when we come to the Thorne Lighting Court of Appeal decision, which you now say you wish to rely.
Yes. That's fair enough. And paragraph 11, he again refers to the overriding objective of dealing with the case justly and having all the available evidence to assess the judge's findings. And there is a statement of truth attested to that, which is not a formality in my view, or shouldn't be treated as a formality. He was putting forward his genuine belief to this court that it was furthers the overriding objective of dealing with this case justly for this court to have all the available Palestinian evidence available to it, including those two decisions. And so, as my lord Justice Popplewell says, there was an expert report of Mr. Atere, which is at page 277 of this bundle, where he made certain observations about the Japan tobacco case first and the Thorn lighting case second. He sets out his conclusions there, which we don't, I think, need to look at for the moment. We then made a responsive application, as my lord said, which was in the separate little bundle, where we did not take objection to their application, but we made a contingent application that if they got permission, we should have permission. We rely on a report from Dr. Husseini, who disagrees with Mr. Atteri's conclusions on these two reports, and to adduce a new Court of Cassation case. And that is where we were at the time of the hearing last July.
But would it be fair to say that Dr. Husseini's report on those cases and the Jordan Cassation case was essentially defensive? It was not these decisions support Kerish's point of view, it was these decisions do not support Opel's point of view in the way that Mr. Atteri seeks to rely on.
I don't think I would accept that, actually. I think what
Can
she...
you just show me which
yes.
part of her report says that they positively support Kerish's case?
Yes, quite well. Because I think the point she is making is that the court decisions emphasise the importance of registration and having an actual agreement. So on Thorn, she deals with that paragraph 33. I'm sorry, it's in the small application bundle.
Yeah.
And I'm looking at page 16 of that little bundle.
33, that doesn't say anything about registration.
I'm sorry,
Paragraph 33 doesn't say anything about registration.
about sorry, I couldn't catch that.
Paragraph 33 doesn't say anything about registration.
Oh, registration. No, I'm sorry. It talks about whether there's an actual agreement. So her analysis of the of those cases is that the court decided them on the basis that there was not a commercial agency contractual agreement within the scope of the law.
Where
How does that help your case?
Because we do have one.
Yes. These cases decided that absence of an agreement was fatal.
Yes.
They say nothing about whether presence of an agreement is conclusive. They say
No,
they
not
don't address
conclusive.
that question, and that's the point she's making.
Yes. No, she says that, but then she has also relied on a.
But that's essentially defensive, isn't it? That's not saying
As
these cases support Kerish's case. They simply say they don't say anything about the registration being conclusive.
Yes, but she also relied, as your lordships, I accept that, in respect of Thorn and tobacco, right. She was, yes.
So that's registration. So in what other way does she say that these assist your case?
Sorry, so that wasn't registration, that's existence of an agreement. That's those two, but then her point is that in Japan tobacco and in the Thorn case, there was no actual agreement.
Yes.
At the right time, yes, that's right. So, and then she makes the point at paragraph 8 onwards of this report that she deals with a new Court of Cassation case called Proctor, and her analysis of that case, which is a Palestinian case, put in the highest court, and her analysis was that, firstly, the court, paragraph 11, there was a distinction between a contract and a letter of appointment, which is the same issue. But then, paragraph 12, she makes the point that that decision highlighted the how significant registration is as a factor.
What it highlights is that because in that case there was no registration, that was fatal. Isn't that what paragraph 12 says?
Yes,
It stated there must be a written commercial agency contract in order to be registered. It further stated that the claim were devoid of a registration certification. So that's a case where there was no registration, and she emphasises that that was a case where there was no registration. how does that positively support your client's case?
I think she draws from it the significance that the court places on the concept of registration.
Where
Whereas
did you say
Judge,
that? That in paragraph 12?
well, it's in paragraph 12, and I think yes, so paragraph 12.
14?
In paragraph 18, yes. So what she takes from that is the primacy of registration as a factor. So obviously the case isn't.
Where did you say anything about primacy of registration as a factor, where it exists? To an English lawyer, it would be surprising if you could get that out of a case in which they simply mentioned that the claim failed because registration did not exist, but of course it's a matter for her evidence. But where does she say the existence of registration? This case shows that the existence of registration is a primary factor in favour of there being a commercial agency.
She does not go as far as saying that.
So what is it in this report that positively supports your client's case?
Well, the point is that registration is an important factor in our case, and we say that Judge Quest dismissed registration as without giving it due consideration.
That's your submission. But
Yes.
just say where you find support for that in what Dr. Hussaini says about these decisions that she's discussing.
Well, I've shown your lordship the
Beyond what's already before the court.
well, I've shown your lordship the passages I rely on. So.
Right, thank you.
Then, so that's the position where we were. And then, my lords, the Palestinian Court of Appeal has handed down its decision, which, as I said, the learned friends asked us to consent to going in the bundle, and it is now in the bundle. And that is behind tab 39 in the supplementary bundle. It's page 605, yes.
Rachel.
605. Now, as I think it was pointed out to me, it's entirely correct, we do not have any expert evidence assisting us with analysing this decision.
Is this admissible evidence on its own?
Well, that's why I'm asking for it to be remitted. It is admissible evidence, but how your lordships handle it is a different
I
question.
think we got to the position that you were seeking to rely on this as fresh evidence in this court. That your application was to admit this as fresh evidence. Is that still the position?
Well, that's my secondary position. My primary position that doesn't seem to be gaining much traction is that the parties have agreed that it should go in the bundle, and that the parties are entitled to make that agreement, and it is therefore in the bundle. We can't make your lordships rely on it, but it's here as a document by agreement.
Is it a question of making us rely on it, or is it a question of whether it would be permissible to place any reliance on it when there's no expert evidence about it at all?
I know. Well, I agree with that, which is why I'm applying for remission. It's all.
That I understand.
So
I'm just pressing you
yes.
on whether you are seeking to say this is fresh evidence on which we should rely.
Well, I would say there are a couple of stages in that analysis. So the question one, is this document actually before the court at all? That's question one. And in my submission, it is before the court because the parties have so agreed. Yeah. And I think in my submission, the parties are entitled to agree between themselves that a certain document should go in the bundle and be before the court.
Let's assume that to be correct.
Yes.
You would have to persuade us, wouldn't you, on the basis of some expert evidence, that this decision would have an important influence on the outcome of the case, such that the judge was wrong.
Yes.
Where is that?
Well, that's why, in fact, what I say is I can't very easily do that, and that's why I'm applying to remit.
But you haven't even got an explanation from your expert about why this supports your case.
Well, what we do have is Mr. Attere saying, and indeed my learned friend solicitor signing a statement of truth saying, and my learned friend putting his signature to
But this is
Skeleton
now
saying-
your application.
No, I agree, but I agree with them. So we have, although I know they're trying to row back on it, but we at least had at one point agreement between people that this was, it was important evidence before this court to look at Thorn and Japan Tobacco.
But that was the first. Those were the first
First
instances.
instance, but a fortiori in my submission, the Court of Appeal.
They were saying that's because they support their case. They
Yes.
say now we don't seek to rely on them. But you then have to say, nevertheless,
Yes.
we want to put them in evidence
I do.
because they support our case.
Well, that's what I said.
And you seek to do so without any expert evidence saying that it supports your case. And even if it were permissible just to look at the decision itself,
Yes.
it's very difficult to see anything in the majority decision which would support your case. Is there anything?
Well, there is in my submission, but just the prior question, in my submission, I'm entitled to say to your lordships that you cannot safely decide this case, or this case cannot be resolved by whatever tribunal without having considered the relevant Palestinian law that has arisen post-judgment and is identified in the Court of Appeal's decision in Thorn. It's even clearer, I would say, which I'll come to in a moment, in Japan Tobacco. So I wonder if I can make my answer your lordship's question about importance when I've shown you your lordship's everything. Is that acceptable? So as far as the Court of Appeal decision goes, we don't have expert analysis. What we have a majority decision and a dissent in that case, from which your lordships can infer something at least as well, that this is a controversial issue of Palestinian law to some extent.
Shows the passages in the judgment you rely upon.
Yes, my lords, let me do that. Because I just have to find my position in the notes, sorry. Yes, so the judgment, the majority decision starts at page 621. And at page 620, it begins with a recitation of the facts and the procedure, and the heart of it really begins at page 627, or sorry, 626. It's where the analysis of the majority can be found. And so in the middle, by the middle of the page, this is the reasoning of the majority. There's a paragraph beginning based on the testimony.
Yes.
So based on the testimony of Mohammed Ja'afra, the court finds that he neither determined nor knew the nature of the relationship between the parties to the action, nor whether an agency existed. The same applies to the evidence of the witness Omar Khalifa, and it's established with certainty before the court through the response of the Ministry of National Economy that no commercial agency is registered for the claimant in the ministry's registers. So just pausing there, in our submission, that is the heart of the majority decision, is that 2 points. Firstly, there was actually no agency agreement, according to the witnesses from the claimant. And secondly, that there was no registered agency agreement. The majority then do go on to say that they refer to, towards the bottom of that page, that there is no reference to a profit margin or commission having been determined as part of the calculation, which I imagine my learned friend wishes to rely on as suggesting that that was a crucial part of their decision. But that has to be seen in the frame of all the Palestinian and Jordanian authorities, which we will come to if we come to it. And then the majority decision says at the next page, page 627, about 4 lines up from the bottom of 627, inasmuch as the aforementioned article, which is the relevant article in law number 2 of 2000 on commercial agents, requires that the agency contract be in writing and specify the terms of the agreement, and in consideration of a profit margin defined in the agreement itself, the legislative purpose is therefore extended beyond the question of writing as a mere condition of proof to its being a condition of formation, and the requirement of writing is in this context a mandatory condition precedent that is coupled with the obligation of registration. And so the and then towards the middle paragraph, or the last paragraph on page 628, having been established that no such agency fundamentally exists, the appellant's claim is without basis in law or fact. And then there is a sentence that I think my learned friend would rely on, where they say it is settled in jurisprudence and case law that the purchase of goods from a supplier or producer for the purpose of resale does not constitute a commission agency.
I think if Mr. Sinclair had wished to rely on this case, which he doesn't anymore, he would also have relied on the top of page 627. The claimant is purchasing lighting and electrical units from the defendant, selling them for a profit without adducing evidence these profits were made on behalf of the defendant in exchange for commission or profit.
Yes, so there are passages in the majority.
Two essential reasons. One, there isn't a commercial agency agreement in this case, and secondly, there was no registration. Those were two separate grounds on which the claim failed.
I think there were three grounds. I think firstly, there was no agreement at all.
Yeah.
Secondly, that nothing was registered, and then thirdly, that the relationship that wasn't
Wasn't one of commercial agency.
although
How does that support a case that registration is conclusive?
no, it doesn't support that.
Well, how does it support your case at all then?
Well, the majority decision, in my submission, what is said about profit margin or commission is obiter dicta. It's not part of they've already found.
Is there such a concept in Palestinian law?
Well, that's why we need some expert evidence, by the way.
Well, we
That's
haven't got
I-
any.
well, I know, but that's why I'm applying for remission. So,
Leave aside what you say is obiter, because you're trying to distinguish what they say as not supporting your case. What is there in this that supports your case?
well, in the
Quite
majority, I
understand
haven't
you
got
say, I can try and distinguish this,
yes.
but what is there in this that positively supports your case?
Well, firstly, what I say is that the majority decision can be distinguished or is consistent with our case, and the dissenting decision is firmly in our favour, is my position. So, and then we don't have an expert, unfortunately.
Where's the expert evidence to this dissenting decision?
Yes.
Is there any significance whatsoever?
No, I know we don't. But in the sense, this is making my argument for me. What the point I'm trying to get across to your lordships is two things really. Firstly, that this is material that is important, stroke crucial, for a fair determination of this matter. And secondly, that your lordships are not in a position to analyse it, and nor am I in a position to argue it, because I don't have an expert evidence. And indeed, your lordships can't really receive expert evidence in a very satisfactory way. So what I think I have to achieve, or I would submit I have to achieve, is to show your lordships that there is a sufficient basis for your lordships to agree with me that this is material. No, not just this. I do want to show you Japan, because that is my high point. But either way, that there is material that your lordships would accept under the Ladder-Marshall test. This is additional evidence that must go before a judge, and it's not, unfortunately, it can't be the Court of Appeal. It must go back to a judge, and this is all regrettable. But there is no fair way for this appeal to be resolved without that happening, in my submission. In circumstances, whereas I will show you, if we get onto it, or I can show you now, the Judge Quest had one Palestinian decision to juggle with, effectively, which was not helpful to him, because it was dealing with a sub-agency, and the sub-agencies are just not covered by the law. So he dealt with that, and then he was forced to consider a whole range of Jordanian cases, which are dealing with a different statute, worded very differently, and which don't really assist. Whereas here we have two Palestinian cases which are dead on point, and particularly if
so far, support the case against you. But I quite understand you say that they're potentially important because of what might happen in the future.
Exactly, not just
but
mine.
That's a separate question.
Yes, it is.
From whether the cases should be admitted for you to rely on them as existing decisions.
Yes.
full stop. And that's why I'm just pressing you.
I
on
see
this.
that.
I understand you say that these may not help you so far, but there's about to be a decision of the Court of Appeal in Japan Tobacco, which on your evidence is going to overturn the first instance one, and the Court of Cassation in this is likely to help you. And to the extent you say, well, these are the background to that, I understand that submission. But the reason I was pressing you really on whether they help you at the moment is that at the moment it seems to me there are two separate aspects of fresh evidence applications. One is whether the existing decisions should be admitted as evidence on their own, as to which the difficulty you, speaking entirely for myself, you currently face is there's no extant application on the respondent side to put them in, and they don't help you. So they don't positively support your case. Then there's the separate question, which is whether Mr. Doodie's second witness statement should be admitted as fresh evidence, which takes these as their background and then says, look at what is likely to happen next. And I quite understand that one might need to understand what these decisions are about in order to determine that. But I'm putting those into slightly different categories. So that's why I'm coming at it from the way I am.
I'm not trying to be unrealistic about what these cases say. Your lordships can read them, I can read them. But in my submission, one sees a movement. For the two first instance decisions were by a single judge, same judge both times, Judge Ashkelon. He has a certain theory that is not adopted by this court. All right, even the majority, and certainly the dissent. But I take your lordship's point that I can't tell you whether dissents have any value at all. Maybe they don't. But we can see from the dissent the way that the next level of court, which is about to publish any moment, I think I would, by the way, withdraw a statement in my skeleton that it's going to be next week. There is a hearing next week, but I can't guarantee that's when it's going to be handed down. But we have evidence that I maintain that it's imminent. All right, so the Court of Cassation has already heard, it's dealt, and it's just waiting to hand down its judgment on this case. And where there is a strong dissent, I'm sorry.
The difficulty, like my lord, I follow the point you were trying to make, Mr. Sinclair, but where is the expert evidence from a Palestinian lawyer to the effect that one of the issues in the Court of Cassation case, the Court of Cassation case, is whether or not registration is conclusive?
No, but that's not my position. As in,
that's the issue. It seems to me that that's the issue, or the only issue that's potentially identified, to which any of these cases might go. In the moment, I can't see it anywhere.
No, my lord, I'm sorry, respectfully, I don't accept that.
What issue in this case does the Court of Cassation go to?
The issue in this case, the reason that Judge Ashkelon, at first instance...
What issue in the present case does the argument that's taken place in the Court of Cassation go to?
Whether a pure buyer-seller relationship can be a commercial agent.
Right.
If that question is resolved in the...
Where's the evidence that was before the Court of Cassation when it was argued?
Well, we don't have that evidence, but we can see from the Court of Appeal that was part of their, whether it was part of their actual reasoning or it was part of their reasoning, was that a buyer-seller relationship doesn't satisfy a test for commercial agency. So the
Court of Appeals decided it doesn't satisfy.
The majority said that, yes.
By the majority.
Yeah. And the dissent...
You need to have some evidence to the effect that before the Court of Cassation, it was argued on behalf of the appellant that a buyer relationship could be a commercial agency within the law, and also some evidence as to how the court had reacted to that argument.
Yes, well, I don't have that information. But I think one can infer from the Court of Appeal decision that the issues that were live in the Court of Appeal are likely to be the same as are alive in the Court of Cassation.
Why should we infer that? Well, I mean, we're very well aware of cases on appeal from us in the Supreme Court which don't bear much resemblance to the argument in this court.
Well,
Better experience suggests to us that's the majority of cases.
the Court of Cassation is faced with a case in Thorn where there is an alleged buyer-seller relationship, and the argument is that that does not give rise to a commercial agency, and the issues that have to be determined are what is the relationship between the parties, was it registered, and is it a buyer-seller or is it a commercial agency? In my submission,
Can you just show us where in the dissenting judgment,
yes.
the dissenting judge says that a pure buyer-seller relationship is a commercial agency?
Well, I draw it from page 635.
635.
Which is in the middle of the dissent. But about halfway down the line, it says, as for the first instant court's adherence, does your lordship have that?
Yes.
To the phrase commission or profit margin to evidence agency, commercial agency or concerns the commercial agent. The laws allow parties to agree on further terms. And then after a little quote, the judge says that's to say the parties may agree between themselves on any other matters besides commission or profit margin that's subject to the principle of agreement between them. The nature of their commercial dealings does not nullify the status of a commercial agent if the commission or profit margin is not mentioned. Accordingly,
It's a different point, isn't it? That was the point the judge made, that it's fatal because of the terms of the Article 5 of the Commercial Agents Law, that the remuneration isn't specified in the agreement itself. That's a slightly different point.
well, slightly different, but it's very much tied into it was tied into the way Judge Quest analysed it, because he said, because the issue, we're getting ahead of ourselves slightly, but the Jordanian law just talks about commission, all right? Whereas, or one of the Jordanian laws on which many of the cases arise talks about just commission, whereas the Palestinian law says commission or profit margin. And Judge Quest had to grapple with what all profit margin means. And he came to the conclusion it means a profit share, because he took the view that my client couldn't have ownership, was outside the arrangement because he owned the products. And he said, therefore, it
I understand that, but the point I'm putting to you is that the point that you've just shown us in this judgment is not about the nature of it, it's about whether it's stated in the agreement or not, because that's what Article 5 seemed to require, and that's what the judge at first instance said was one of the reasons that was fatal. And this dissenting judgment seems to say it's not fatal, that it's not stated in the agreement. Isn't that what's
I think it's a
being dealt with
combination
at this stage?
I'm not sure that's right, but respectfully, I think it's a combination of whether it's mentioned, but then if your lordship turns the page to 636.
We've got as far as the bottom of 635, where the critical bit is the bit at the beginning of the last paragraph. It can't be maintained that specific mention of the commission or profit margin is a prerequisite.
Yes, so
and that's the point I was putting.
Yes, that's right. That's correct.
Right.
But the judge is saying at the top of 636 that it's sort of the method of the remuneration is a matter for the agreement between the parties, in the sense that there's no magic in identifying whether or not the particular relationship is by commission or an amount of profit or so on. It's a matter of identifying what the parties have agreed between themselves.
Yeah, but it's got to be remuneration.
Yes, some form of remuneration. Well, there's a question what the word remuneration. I think your lordship may be loading the word remuneration in a certain way that I wouldn't accept. Obviously, the parties are dealing for profit in some way, so that's a form of remuneration as well. But my lord, so that is the Thorn case. Obviously, I accept. I'm not a fool. I know that the majority decision would be relied on by my learned friend, but in my submission, it's fairly weak milk from his perspective, and in my submission, the dissenting judgment is helpful to us. But obviously, we can't interpret it very completely, or even very safely, without expert evidence. And then, my lords, just going back then, which is really the high point of my submission, is the Japan tobacco case. And I'm sorry.
Where do we find that?
Well, what we find is that we know there's a first instance decision, which for your note is at page
This is Judge Askeland.
yes, this is another Judge Askeland decision. But
550.
550,
37.
yes, correct. I'm sorry. 551. Yeah. Thank you. And that decision is against me. And in that case, the judge found that it was just a buyer-seller relationship and therefore was not a commercial agency. But we know that the Court of Appeal in Japan Tobacco is going to hand down its decision in the next few months. And there's a different, Mr. Atere says it's going to be in January 2027, which is 6 months' time. Mr. Shaukat, who's the lawyer on the other side in that case, has given evidence for us that it's going to, he expects it in the next 3 to 4 months, but 3 to 5 months. So anyway, in the next few months, a decision of the Court of Appeal is going to be handed down. But the crucial point is, as your lordships will hopefully have picked up, is that the Court of Appeal in that case has appointed experts to value the loss under the law. And it is Mr. Shaukat's evidence, and that's the court appointing the experts, it's not the parties doing it. The court has taken the trouble, having heard the appeal in that case, to appoint experts to assess damages. And the evidence of Mr. Shaukat, and I would submit is fairly obvious, is that where in circumstances where a Court of Appeal does that, there is pretty clear what their decision is going to be.
Why is that obvious? If it would be perfectly sensible if they wanted to make sure that if they allowed the appeal, they didn't have to remit it, to make sure they had all the evidence of damages before them. But Mr. Ateri's evidence is they do that in other cases, and they've done it in cases in which they've dismissed the appeal.
Yes, well,
So to suggest it's obvious is,
well, it's,
you're perfectly entitled to say that's what Mr. Shaukat says, but Mr. Ateri says the opposite.
well,
How are we to resolve that?
well, can we look at Mr. Ateri, please? And so I think your lordship's referring to Mr. Ateri's witness statement
Yes.
of the day, and in particular paragraph 11 of that. He says, he refers in this context to 2 trademark infringement cases, in which 2 different courts reopened the pleading stage and appointed an expert to calculate damages. However, both courts dismissed the claims. And
Where are you, Centre?
this is Mr. Ateri's recent witness statement, which is
We've got loose.
it's not in the bundle, it's loose.
I've got it loose.
So he refers in paragraph 11 to 2 cases, and those, do your lordships have the translations of those 2 cases that have recently arrived?
Across the cafe and ever ready battery.
Yes, thank you, yes, exactly. So if one looks at Costa, for example,
Before we do this, are you inviting us to form a view as to whether that evidence should or shouldn't be accepted? I reference the underlying decisions, and that's not how you go about deciding questions of foreign law.
I am aware, my lord, but that's why I'm asking this whole matter to be remitted. But I only have the materials I have. These cases arrived yesterday. So I can show you what your lordships have to make a decision on the evidence in front of you, and that decision may be.
I understand that.
Yeah.
Your submission was that it's obvious, and that Mr. Shaukat is right in saying we can proceed on the basis that the Japan tobacco appeal is going to be allowed. All I'm putting to you is that's disputed,
Yes.
and we're not in a position to resolve that dispute.
Well,
So that may or may not be the case.
well, can I show you? Can I make my submission on this, and your lordship can decide whether it's good enough for you to feel confident about. But in my submission,
Of course, I'm not going to stop you, but I am, and I'm speaking entirely for myself, slightly anxious that we should spend time looking at the underlying decisions on which he relies in order for you to make a submission that we should reject his evidence at paragraph 11, which is, I think, if I've understood correctly, what you're inviting us to do. Is that right?
yes.
And how can we do that?
Well, let me show you.
These aren't decisions, are they, that it is for us to interpret? We've got them in translation
Yes,
without the benefit of hearing
I agree.
expert views about them. I mean, I don't want to stop you, but you understand my reluctance to spend time on this, and
I agree.
I need to be persuaded that it's a proper exercise.
Well, can I have to show your lordships because they have put forward this evidence, and I have to deal with it. And
No,
and
you
the
don't,
only
with
way it
respect.
means I have
Mr.
to deal with
Sinclair
it.
is no longer relying on it, so you don't have
He
to.
is relying on this statement. He is. He put this in 2 days ago. Mr.
Well, that
Terry's-
is in opposition to your
Yes,
wish to have this remitted to the
correct.
judge.
So it's in evident. He is still relying on Mr. Terry, sure. So I have to respond to it, and but
I'm with you on that, but what I'm having difficulty is how can we
yes,
go behind what he says simply by reference to ourselves looking at the authorities on which he relies
I agree.
without
It's not-
hearing evidence from him or from Mr. Shawkat. That's the difficulty.
I share your lordship's concern, but we are where we are. I have to.
But isn't where we are that so far as the fact that the Court of Appeal have asked for an expert to address damages is concerned, that may or may not give us an indication as to whether an appeal is going to be allowed. And we can't decide whether it is because the experts disagree on that. So that may or may not be indicative that the appeal is going to be allowed. Isn't that really where we get to?
Well, I'm trying to put it further than that,
Really? That's-
and I think I can. And if you will indulge me for 5 minutes or maybe 3 minutes, we'll see where we get to. And obviously, it's not an ideal exercise, but I have to deal with the materials I have. So can I just show your lordships the point I want to make, which is in the Costa decision. And it's page 14 of the translation. This is I assume the bit that Mr. Terry is referring to, page 14 of the translation, 3 lines to the top. It says at the hearing on the 4th of August 2021, the court determined pursuant to Article 166 of the procedure law to reopen the pleadings and to admit expert evidence in the action in accordance with counsel for the claimant's skeleton. Does your lordship see those?
Yeah.
So in other words, that appears not to be an example of the court appointing experts, but instead of the claimant adducing evidence which the court allowed of expert evidence. It's not a question of the court appointing an expert. So it's not a good example, a counterexample by Mr. Terry. And if I can then briefly show you the Everready case, which is equally brief, page 16 of the bundle of the translation. It is a case where the court appointed an expert, I accept that. But page 16 of the bundle, about 5 lines from the top, it says the court accordingly finds the claimant has failed to prove the pecuniary and non-pecuniary damage it sustained as a result of the use of the trademark. In other words, and if one reads the decision, one sees that the case succeeded on liability, but they failed to prove the loss was caused by the actions. So that is also not a case that supports Mr. Atteri, because it's an example of a case where the expert's report was material to the decision. So those are not examples of cases where a court has appointed an expert in circumstances where the party is going to lose. But even if your lordships are reluctant to draw firm conclusions from that, what one can say is that we have Mr. Atteri, who has been scrabbling around trying to find authority to support the proposition that where a court of appeal appoints an expert, having heard the appeal, that doesn't indicate that they're going to grant the appeal. And what he's found, 2 cases from 10 or 7 or 8, 9, 10 years ago, which are both first instance decisions. They're not Court of Appeal decisions. He hasn't actually found any other example of a Court of Appeal acting in the way that Mr. Shawcott says it's obvious that they're acting. So that's all I'm trying to say. But the point I'm making, my lords, is that if it's right that in Japan Tobacco, the Court of Appeal are going to grant the appeal and are going to do so in 3, 4, 6 months, then that would be absolutely crucial evidence in this appeal, because the reasoning of Japan Tobacco, as Mr. Atteri himself said back when he wanted to rely on it, was that there's a case, I can show your lordships the evidence if you want, but there is the case of a buyer-seller relationship only, and therefore that's why the judge found it failed. Now, if the Court of Appeal says, actually, a buyer-seller relationship can be a commercial agency, then that is obviously critical evidence in this appeal. My lords, can I just show your lordships another point that I forgot to mention?
Do we know what was argued in the Court of Appeal?
Well, we have the evidence of Mr. Shawcott and...
Well, show us that evidence, please.
Right. Yes. It's an exhibit to Mr. Dahoud's witness statement. No.
It's behind tab. Well, I've got it behind the tab 3, but I don't know whether it's tab another.
The witness statement's behind tab 3, the exhibit's behind tab 4. Mr. Shawcott's statement is I think, the first. Yeah, it's the first document in the exhibit.
Yes. So he sets it out in various sections. So the first bit in bold is is an introduction. Then he sets out a section called First, where he sets out the procedures in the case. Paragraph 9 of that, he talks about how Mr. Atteri had objected to the appointment of expert reports, and he said that the court decided to reassign the task for the experts. And then he sets out in the third section his conclusion in this matter. And he says at paragraph 1, the course of the proceedings and the measures undertaken by the Court of Appeal lead to only one legal conclusion, namely the definition of a commercial agent as set forth in Article 1 and 5 is applicable. The court has therefore gone beyond the legal characterisation adopted by the court of first instance.
What does that sit with what he says in paragraph 2, which is that it reflects the court's inclination towards recognising the appellant as a commercial agent? It's not quite the language of having decided, is it?
Well, that may be that. I think that's over analysing the meaning of the word inclination.
What was argued? What was the argument? I mean, the Court of Appeal could decide that the agreement had been misinterpreted. It wasn't just a buyer-seller relationship. It was something else, and therefore it was a commercial agency. That's one possibility. Or they could say, well, you don't have to be registered, despite the fact the law says you do. That's another possibility. I mean, it could be all sorts of things.
Respectfully, that's not right. They would have to find that a buyer, in order for the appellant to win in that case, they would have to find that a buyer-seller relationship was sufficient. That's a necessary ingredient of success. in
Where's
that
the
case.
evidence to that effect?
Well,
Where's
the
the evidence that the Court of Appeal would have to find, as you just put it, a buyer-seller relationship with the commercial agency?
because we see that from Mr. Terre's original witness statement.
Where's that?
Yes, which is in the.
Can we just, sorry,
Sorry.
It's in the application to refresh it.
Yes, well, it's in the no, it's in the supplemental bundle. Tab 10, page 277. And at the bottom of the page, he's summarising the key findings in the first instance court's decision, where he said that the key finding was by applying the criteria of commercial agency set by law, the court determined the agreement and relationship between the two parties fell outside the scope of the commercial agency, instead constituted a seller-buyer relationship. This conclusion was based on the court's analysis of the business model between the parties, which involved purchasing goods and reselling them at a higher price. And then the second bullet over the page, at 278, the court addressed the issue of registration. It noted that the legal status of the plaintiff is not determined by the registration, so long as the elements of a commercial agency are not satisfied. So the Court of Appeal, in other words, the entity was registered in that case, but was found not to be a commercial agency because of the nature of the buyer-seller relationship. So it's a crucial decision. As my Lord Popplewell kept asking me, where's the decision that says what I need? It is this one in the Court of Appeal, if the appeal succeeds, because it's a case of a buyer-seller relationship that's been registered, which is what we have. Well, I don't accept as buyer-seller, but let's say that's what they say we have. And so if it's the case that the buyer-seller relationship that's been registered is a commercial agent, then that is crucial.
I'm not sure you can put it that high, can you? I mean, even Dr. Hussaini recognised that not all merchant transactions in which someone buys, imports and resells amounts to commercial agency.
No, I don't.
So buyer-seller relationship is not going to be held on her evidence that is a commercial agency, but I think you're saying it's not inconsistent with it being a commercial agency. That's what you would hope to get out of it.
That's what I would hope, and it's not just a speculative hope. What I'm trying to persuade your lordships is that it's not a speculative. And can I just make at that point slightly good by reference to some authority, which I meant to take your lordships to. It's in the supplementary bundle. It's at tab 24, which is at page 426. And this happens to be the one Palestinian decision that is in the same ballpark, which is the sub-agency case. But I'm relying on it for a different point at the moment, which is, if your lordships could go to page 433, where the court identified the sixth ground of appeal, which was that this court first instance had erred when disregarding the appellant's request to appoint an expert to estimate the value of damage and compensation without stating reasons. And the court found that where it was established, like 4 lines from the bottom of that paragraph, whereas it was established that the appellant has no right to compensation in the present case, the appointment of an expert to estimate the value of damage under the said circumstances is proved to be useless and unfeasible. In other words, that is authority for the proposition by the Court of Appeal that appointing an expert where a party has not proven their right to compensation is useless and unfeasible. And the same, just to show what the Court of Cassation said in that same case on that same point, it's in the next tab at page 440. Page 440, this is the Court of Cassation in the same case, the Shell Oil case, in the bottom paragraph, regarding the 13th reason, where the appellant faults the appellate court for not appointing experts to assess compensation value. We see that this reason does not undermine the appeal judgment. The appointment of experts for estimating fair compensation necessitates proving the existence of the agency, the commission agency, and then proving that one of the parties reneged on the agency, which was not proven to the court. Therefore, there was no need for appointing experts. So that, in my submission, is higher authority than Mr. Atterre's two first instance decisions that don't actually support his point. So, my lords, to sum up, I would submit it is clear that there is highly material Palestinian law evidence either in existence or imminent, and certainly imminent, in the talk about the Japan tobacco case in particular, where there's a Court of Appeal decision coming in 4, 5, 6 months, which we can be highly certain, I would submit, has granted the appeal.
Would your submission be that remission to the judge should involve awaiting any decision on appeal to cassation in Japan tobacco?
I think I would leave that up to that judge to decide based on evidence that is put to him. So I would leave that up to him. But I would leave it all up to him in the sense that all directions. And he may want to wait. He may not want to wait. But even if he doesn't wait, in fact,
Well, I think the logic of your submission is he ought to wait.
he ought to wait. But there might then be a debate whether he should wait for the Court of Cassation in that case, assuming it goes to cassation. So I can see that debate happening. But I don't think your lordships need to resolve that.
Well, do we not? We're being asked to remit.
Yes.
So forgive me for a moment.
Sorry.
We're being asked to remit, and one of the factors that may come into our consideration is how long is that likely to be for? And I think there's a difference again between the experts as to how long it takes to get to cassation. I think Mr. Atterre says anything between a few months and 32 months. So if it's a question of waiting until there's a final decision in Japan tobacco, we may be looking at several years.
Yes, so we know, or the evidence is, that a decision in Thorn and Court of Cassation is imminent, or is coming in the next few months. That's the evidence. That's in. No,
You're talking about Thorn.
in Thorn, exactly.
Whereas that could be 6 months away.
No, I think Thorn. It's just said it's in. That's the one where by mistake I said next week. Yes, but the actual evidence is it's
That's Mr. Shortcut.
Yes, no. Mr. Shortcott's not involved in that matter. That's Mr. Dahoud. It's in his witness statement, paragraph 12.
Shortly.
Yeah, so an earlier version of that had said next week, because there is a hearing next week, and that's why I made the error in my skeleton. So it's not next week, but it's shortly.
Well, the difficulty is that saying that it's going to be sometime very soon. So he says in paragraph 12, it's expected shortly in the Thorn. And then in 13, the judgment is also expected imminently from the Court of Japan tobacco. Just pausing there, if I read those without more, I'd say that the adverb imminently suggested something even sooner than shortly. We're now told that imminently actually means anything up to 6 months. So shortly may mean 9 months, 12 months, who knows?
I can't add to the.
No.
So The real risk, my lords, is that this appeal proceeds on the basis of, well, I assume that the only question is whether you proceed on the basis of the evidence as what it was in front of Judge Quest, or remission, and that there's no halfway house. But it would be an alternate reality in my submission for this appeal to go forward on the basis of the material that was before Judge Quest in circumstances where all he had from Palestine was a Court of Cassation case in the Shell Oil, which was dealing with a sub-agency, and therefore didn't assist him. And if you look at his judgment, he doesn't really get much as direct assistance from that case. Certainly nothing that is material to the decision in that case. Whereas we know, your lordships know for a fact, there are two cases that when they suited my learned friend, he accepted were crucial to be heard for a fair hearing. When it doesn't suit him, he's changed his mind. And one asks, why has he changed his mind? Which does support the fact that Mr. Terry has told him what's coming. But in any event, we say these decisions are crucial, either the ones that are currently here, or certainly the ones that are coming very soon, whatever that may mean. And that your lordships have to deal with cases justly, and in accordance with Ladd and Marshall, this is evidence that couldn't have been raised earlier. It is important. It's obviously important. It's not just important. It is the critical evidence that Judge Quest would have used in my client's favour or against it. But he would have not had to wade through Jordanian cases under a different statute. And these judgments are authoritative. It's in accordance with the overriding objective for this evidence to be introduced, but your lordships are not in a position to deal with it today, or indeed ever, probably, because you need to have some expert evidence to assist you. And so the only fair mechanism is remission, and the prejudice to my learned friend, he didn't really identify any special prejudice to himself. Obviously, the prejudice is delay, I suppose, but that's more prejudice for my client, who's being kept out of money, if he's right. They have some uncertainty. But that weighed on the other side of the scale is a complete risk of a miscarriage of justice here.
Well, there's public interest as well in finality in the administration of justice and the use of court resources and matters of that nature.
Well, that's fair.
Quite apart from any private interest in delay.
Fair observation. But I would say what weighs very heavily against that is a risk of a miscarriage of justice in circumstances where my client succeeded on all the issues in this case, apart from this one, as a matter of Palestinian law, which was an issue raised very late in the day in that case, and where it seems that there is going to be very significant Palestinian authority in our favour. There seems a very high risk.
Might or might not be.
Well,
At Cassation level,
yes.
at Cassation level,
Yes.
what is the basis for saying
No.
that it's likely to be in your favour?
No, nothing.
And I think it was Dr. Husseini's evidence, but I may have misremembered, that it's only at Cassation level that these matters have any importance or precedent.
Yes, in Palestine, that's right. But the question for your lordships, I think, is what would the highest court in Palestine do? But which is obviously helped by seeing a cassation case, but is also helped by seeing a Court of Appeal case. Yeah, so unless I can assist yours, that's all I have to say on that.
Thank you. Mr. George, do you want to say anything?
My Lord, I'll take it as briefly as I can, but may I adopt my Lord Justice Popplewell's distinction between that part of the application which relies on judgments which currently exist, which in a sense falls within more standard Ladd and Marshall propositions, and that part of my learned friend's application which is based on judgments which do not exist, but is simply on the basis they may exist at some time in the future, which to the best of my knowledge is an extremely novel application. And as my Lord Justice Popplewell has indicated, it does beg the question of, well, when do you stop the clock? There could always be another cassation decision, another case that goes to the Court of Cassation. And as you will have picked, you do not need, or you have picked up, you do not need permission to appeal to either the Court of Appeal or the Court of Cassation in Palestine. It appears to be an appeal as of right, as we're told by my learned friend's expert evidence. So may I say something briefly about those parts of my learned friend's application based on the current judgments? And of course, there is no such application. True it is that I made an application, which I do not pursue. But my learned friend cannot simply adopt that because my application was a completely different application. My application was to say, these authorities are important because the judge showed he was more right than the judge could have realised at the time because they are subsequent lower court decisions applying the Court of Cassation decision which the judge relied on. And I take the position, we are now 2 years on, we have seen the delay, that I will not make that application. It's not important enough and I don't make it. But it doesn't assist my learned friend, even if he can show that I might have got it in if I'd pursued that application. Because my learned friend has to show that these same decisions show the judge was wrong. Not more right than he might have thought he was, but actually wrong. And in my respectful submission, as has been explored in the course of the argument, there is absolutely nothing in the evidence put forward by my learned friend that could suggest that. And there is no reason why this court should be presented with an application to adduce fresh evidence without having that expert evidence available to it. The decision of the Court of Appeal in Thorn Lighting was on the 29th of September 2025. It then became obvious that the dissent was there if my learned friend wished to apply to adduce it. We were accused of being half-hearted, but may I just invite the court's attention to my supplementary skeleton argument of the 8th of June 2026. Paragraph 17 we said the respondent's position is that the court can determine the appeal on the basis of the evidence which was before the judge. No further evidence is required to determine the issue. At paragraph 22, we reiterated, in those circumstances, the respondent submits that the court does not need to admit further evidence in order to determine the appeal. The appeal can be decided by applying the ordinary appellate test to the judge's findings on foreign law. And at 25, the appropriate course is therefore for the court to determine the appeal on the evidence before the judge. So in our respectful submission, we made our position absolutely clear on the 8th of June. And there was a debate before this court last year about the likely need for remission if we pursued that application. It was something we were obviously always going to consider. But we make our position clear on the 8th of June. It is not until last week, the 26th of June, I apologise, 22nd of June, I think, that we received the application from my learned friend. And the very least in my submission we are entitled, and this court is entitled in those circumstances to expect, is that that application will have the fresh evidence which my learned friend wishes to admit. And if that is expert evidence saying that these two cases support his position, so be it. But there isn't any of that. There is nothing as far as the existing unappealed decision is concerned, which could form the basis of saying this is important in Ladden-Marshall terms because it shows that the judge was wrong, as opposed to being more right. And obviously this court will give anxious scrutiny to an application which seeks remission, bearing in mind the extra costs, the disproportionality, and the public policy principles of finality in these areas. It came as something of a surprise to us that we were not able to find an authority where this has actually been considered a change in foreign law, but we haven't, and nor has my learned friend. But as a point of principle in our submission, and looking at the Ladden-Marshall test, it must be the case that the court will deal with anxious scrutiny about whether a new foreign law decision actually has an important influence, or is likely to have an important influence on the appeal, given that the judge heard a large amount of foreign law evidence and had a Palestinian Court of Cassation authority before him. And that is particularly so where the new authorities do not actually support in their judgment the position of the party who seeks to rely upon them. My Lord, you have seen, if I may I just remind my Lord of page 628 of the Thorn Lighting decision. It's at tab 39 of the supplementary bundle. lord sees on the right-hand page, there's a marking saying stamp 1 illegible, and I use that just as a placeholder, the line beneath that. And as the facts of the action indicate, there is nothing in the evidence to establish the existence of a commercial agency contract between the parties, and that the substance of the matter is that the claimant was purchasing goods and reselling them directly and in its own name, and was the party that determined the price and the profit margin. And then we refer in this regard to the decision issued by, and then the references to Shell, which is the Court of Cassation case in Palestine. That was before Judge Quest. And hence, my decision that we'll rely on that Court of Cassation decision. These are just other cases applying. So in my respectful submission, my lord, there is nothing here that could support the basis for an application by my learned friend that these satisfy the ladder-Marshall test from his end of the telescope, which is he needs to show that they demonstrate the judge was wrong. And my lords, you have already taken my learned friend to the parts of his expert evidence which deal with this. May I just remind my lord of the relevant paragraph numbers in the expert report of Mr. Husseini. So page 12 of the short application bundle, if I may. Dr. Husseini. I apologise, I say Mr. Husseini, Dr. Husseini, I apologise. She. Yes. Yes, she gave evidence at trial. My memory isn't fading that badly, my lord, I'm grateful. So at page 12, paragraph 6, and I know my lord has already highlighted this point, that's just the reference to only Court of Cassation as binding precedent.
Yeah.
I highlight the last sentence, just the point I made earlier, no permission required to go to the Court of Cassation. At paragraphs 58 to 63, various conclusions. This court has already read them, but I simply, in my submission, my Lord Justice Popplewell was entirely correct to say they are defensive points. It is a fair summary of this report to say that her position is these new decisions, Court of Appeal, in Thorn Lighting and Japan Tobacco, don't assist you, respondent, because they have no precedential value and there are other issues involved that were determinative. There is nothing here that says there is positively supports the case that she wishes to run. So in my respectful submission, the application based on the judgments that do exist, unsupported as it is by material expert evidence as to why these cases support my learned friend's case, should be rejected. May I then just deal briefly with the case based on the non-existent authorities, which may come imminently shortly next year, sometime in the future. May I start, my lord, this is an application made last week, which could have been made at any time previously, and insofar as it is unsupported by proper detail as to what the issues in cases are and when judgments are available, that in my submission is a matter which should be held against and weighed against those making the application. The position is there is no credible evidence on which this court can find any basis on when this judgment is available, beyond the fact it will doubtless be in the next 3 years, which is the amount, probably the high point of Mr. Atterer's evidence. As my learned friend has fairly accepted, the 6th of July date in his skeleton was an error. We had pointed out that we could see no basis for where it had come from. My learned friend's words, and it was his witness statement and his application, but the highest it was able to be put shortly at paragraph 12 and soon at paragraph 16.4. And my Lord Justice Flaux has already indicated his use of the word imminently and the context in which that appears to appear. I mean, I just again, for the references, highlight what Mr. Atterer says about that at paragraphs 5 and 6 of his recently served witness statement. It was served on Friday. Do all members of the court have a copy of that statement? May I hand a copy up to my Lord Justice Flaux? I will take it, if I may, I'll hand it up loose so I can keep it in its bundle. But thanks very much. And so may I just invite the court's attention to paragraphs 5 and 6. Mr. Atterer has gone to his files, he's looked at the dates he has available as to a Court of Cassation decisions. And you'll see the period from the date of the receipt ranges from 8 to 32 months. There are some at paragraph 6 which remain outstanding for longer. And the only fact this court has, which it can take as true on common ground, is the date of the decision that is under appeal. The Thorn Lighting decision was 29th of September 2025. But there is no basis on which this court can proceed on any other basis than there will be a Court of Cassation decision, unless it settles, at some point in the next 3 years. And you don't have expert evidence as to what the issues are. You do know it is perfectly possible you could have a judgment that says, as my Lord Lewison indicated, takes a different issue or decides it on a basis that isn't actually going to help us, whatever the actual result of the decision is. But I accept they may say something of relevance to this case. But this court is being asked to remit a matter, not because it has fresh evidence before it, but because it's expected that there will be some at an indeterminate point, up to 36 months in the future. And in my submission, that is a gross offence against the principle of finality. And I don't want to be over extreme, but of course, in one sense, it will never end. We had a Court of Cassation decision in 2022. We'll have another one in Thorn Lightning. We may well have another one in Japan Tobacco in due course. And of course, there may be cases at any point started which go up through the appeal court, and of which one party or another could say, well, I think this might come out in the next year or so, and that might help me. Of course, I'm sure everyone wants to stop the clock at the most favourable moment, but this court, the objective and neutral factor as to when we stop the clock is the date when a judgment was given by this court. And if we come to an appeal hearing, in my submission, absent the most exceptional circumstances, you should not be able to say, well, this judgment may not exist, but it might in the future, and it might be in my favour, and it might change the result. There's simply no place for a principle of finality if that is the approach that's adopted in my respectful submission. And may I make 2 further points on Japan Tobacco. Just standing back, it is in my submission an extraordinary submission for this court to be invited to second-guess the decision of a judicial body in Palestine on the basis of a procedural direction which they have given. The position is there is ongoing proceedings in Japan Tobacco. There are matters still to be determined, and this court can only safely and fairly proceed on the basis that it doesn't know what the result will be. Mr. Otero has shown one example of a court reopening the grounds, another example of expert evidence being admitted by reopening the pleading and appears at the suit of one of the parties. May I show one more important reference in this regard in my learned friend's evidence, which was submitted in support of this application. And I'm afraid this is the unpaginated exhibit of Mr. Dahoud, MD6. Now it's electronic page 90, and it's exhibit YSA3, and it's the grounds of appeal in Japan Tobacco.
YSA3.
YSA/3, so it's a sort of sub-exhibit within the exhibit.
How far is it?
It's about 5/6 of the way through, I would say, my lord. And if I may hold it up, it has a sort of paginated language development centre heading.
Yeah, it says before the Jerusalem Court of Appeals.
Before the
So-
Jerusalem
I'm very
Court of
grateful, yes,
Appeals.
highlighted and underlined. So these are the grounds of appeal. So may I just show you paragraph 6 over the page? So there's various grounds of appeal, some of which are and some of which are not particularly relevant for the issues in our case. But this is paragraph 6. The judge of the Court of First Instance Economic Chamber, with due respect, erred in dismissing this action solely on the basis that the appellant company had failed to prove that it was a commercial agent of the appellee company without examining the material and moral damages sustained by the appellant as a result of the arbitrary termination of its status as an exclusive commercial agent. Even assuming arguendo that the appellant was not a commercial agent, which assumption is expressly denied, the appellant company would nevertheless remain entitled to material and moral compensation arising from the arbitrary termination effected by the appellee company. The trial court was under an obligation to examine such damages, provide adequate reasoning thereon, and ultimately render judgment in favour of the appellant company. However, the trial court, with due respect, failed entirely to address these issues and confined its reasoning solely to the finding that the appellant was not a commercial agent. This renders the judgment's decision in reasoning and justification, and therefore subject to revocation and annulment. Now, my lord, there's two important points from that passage, even in the absence of expert evidence. First, my lords can see it was an independent ground of appeal that damages should have been assessed and considered, and so it may well be that the Court of Appeal, in the light of that allegation, decided effectively to close it off by appointing the experts. And secondly, my lord, and nobody in this courtroom can say whether it's a good point or a bad point, but a point is being taken in Japan Tobacco by the appellants, that they're entitled to damages and compensation regardless of whether or not they are a commercial agent. Which means, as a matter of logic, it is at least possible that this appeal could proceed, even if the appeal is successful, on the basis of an argument and an issue that has nothing to do with our case. They may just say, well, we're not going to decide whether you're a commercial agent or not, we agree. It doesn't matter. And this is all part, in my submission, of an inevitability when one is being asked to remit a case on the basis of a judgment that doesn't exist but might exist in the future, and you're being asked to read the smoke signals as to what it might say and when it might be available. The true position, looking purely at the facts, we've had a trial before a commercial court on the best evidence available to him at that time. No party is making an application saying that the fresh evidence that is available today is going to make a difference, or if my learned friend is, he simply does not have the material to put it from the way he needs to put it to show that the judge was wrong on the judgments that exist today. And it would be wrong in principle in all but the most exceptional circumstances for a court to speculate about what might happen in the future and to remit for potentially years, as my lord has said, either waiting for the Lighting Court of Cassation decision or waiting to see if Japan Tobacco gets appealed to the Court of Cassation or waiting to see what else might happen. That would be a most unsatisfactory way, in my submission, for this court and the mercantile court below to proceed.
That paragraph clearly demonstrates that one of the things was being argued was that they were entitled to damages, irrespective of whether they were commercial agents, because of the arbitrary termination of the agreement under the terms of whatever the agreement was. We have an agreement which is different.
Precisely.
And has to be construed in a different way.
Precisely. And I mean, my lord, and one shouldn't see everything through to the right, but one can quite see in a different type of case you could have had the same here. A claim both for wrongful termination, if you'd had different termination provisions, and a claim under some agent's regulation. That's what seems to be happening here. But for present purposes, the point is we just don't know what decisions the Court of Appeal will make, when they will make them. But yes, it's possible they'll say something relevant to our case, and it might be helpful to my learned friend. But that is such a speculation within such a large range of possibilities. It would be wrong in my submission to remit a case on that basis. Unless I can assist my lords further on.
Thank you. Mr. Sinclair, do you wish to reply?
Just one point on the half-heartedness or not. Just on my learned friend's skeleton argument on the 8th of June, it did include the paragraph 19, where he relied on the new Court of Appeal decision in Thorn as allegedly supporting the judge's conclusions on Palestinian law. So the position as we read it on the 8th of June was that he did want to rely on that further Palestinian law evidence. That was the only point I wished to make.
Right, we'll just rise for a couple of minutes. Don't go away.
Court rises.
It's not.
What happens to them,
That would be funny.
Vagaries. Tactical skirmishing.
That would be amusing. Hadn't thought of that.
Court rise if able.
Mr. Sinclair, we refuse the application to remit for reasons which will be explained in a written judgment in due course.
Thank you, my lord. So, carrying on, there are the following issues to determine. Logical order, I would suggest, is as follows. Firstly, as a matter which is really the respondent's notice point, which is as a matter of contractual interpretation, should the court interpret the words national law in the contract as meaning Palestinian law? The second issue, which has gone away from our perspective, is whether there are any public policy reasons that your lordships may feel that so I think that issue has gone away completely. Yes, so we can ditch that, which is good. And then the third issue is, I would suggest, is this English law question: is how should this court approach foreign law issues? Which several members of the panel are very familiar with as a question. And then the final question is, well, what's the answer on Palestinian law, or did the judge get it wrong and according to the test, such as it may be? So if your lordships are happy with that, I will deal with the contractual interpretation question. That arises out of the dealer sales and services agreement, which is in tab 1 of the supplementary bundle. So this document, tab 1, can I just apologise in advance that there are some annotations here and there in the document. This is the best version we have, so if you can ignore those, please. As you can see from the contents, there are 23 articles and then a number of annexes. And this document is relevant to two questions on the appeal. Firstly, the one I'm about to deal with, about the meaning of national law. It also is relevant to the ultimate question of whether we are a commercial agent. So to save going through everything twice, I'll just do both points now, if that's convenient for everyone as we go through the document. Yes. So can I invite your lordships to look at the first recital, which is on page 9, which specifies that Opel and dealer, which is a generic term identified separately, desire to promote the sale of motor vehicles, which is defined term, which we'll come to in a moment, and to provide parts, accessories, and to provide service, including warranty, maintenance, and repair work. So motor vehicles is defined at clause 1.15 as meaning effectively Opel cars, Opel and Vauxhall cars. And we'll come to dealer, which is defined in clause 1.16 as Opel dealer, which is a business that meets the dealer standards established by Opel for the sale of the motor vehicles, Opel parts, accessories, and to provide after-sales service, and which has been appointed by Opel. And I draw attention to the word appointed here. And so that is what an Opel dealer means. The actual name of the dealer is identified in an annex. And going back to the recitals, I'm sorry.
Dealer and Opel dealer.
Well,
The dealer is defined at page 51 as Kerish.
yes.
an Opel dealer can be someone else who's supplying. It's not exclusive. So Opel dealer's not directing itself specifically to Kerish, is it?
Well, I think that becomes clear from the second recital, maybe on page 9, which is that Opel desires to appoint dealer, which is just the one that's defined as Kerish, as its Opel dealer in the area of responsibility. And again, the area of responsibility is also defined in an annex, which we will come to, but is referred to in clause 1.6 as being the geographical area defined by Opel. And then clause 1.9 defines dealer operations as all operations contemplated by this agreement relating to the sale and promotion of the vehicles, parts, accessories, and recommended programs, and to provide service for motor vehicles, including warranty, maintenance, and repair work. And then I think we can move forward to clause 3.1, which is on page 11, which identifies those representations and warranties by the dealer. And in particular, if I can invite your lordships to consider clause 3.1.10 on page 12, which is a warranty that all of dealers' business activities which may affect Opel shall comply with European competition law, and/or, where applicable, national competition rules as well as all laws and governmental regulations relating to its performance. So that is a clause that includes the word national, which becomes relevant later in my submission. But for the moment, I point out that because it says where applicable, that rather suggests that the word national doesn't have a fixed meaning. It means different countries, some of which will have applicable competition rules and some of which won't. Clause 4.2 is on page 13 and identifies the area of responsibility, which is a geographical area which is identified in the annex, which we will come to. 4.3 identifies the rights that have been granted to the dealer. And then, more importantly, clause 4.4 identifies the dealer's responsibilities. It says, dealer shall endeavour to conduct and perform dealer operations in a manner which exceeds customer expectations throughout the purchasing and ownership experience. Then there's mandatory language, dealer shall do a number of things. And clause 4.4.1 is actively and effectively sell and promote the vehicles and so on. 4.4.2, actively and effectively promote the dealer operations to all customers, and in particular those in the area of responsibility. And then 4.4.4, the dealer is required to provide maintenance and repair services to customers of motor vehicles, regardless of where the motor vehicles were purchased. So if you have purchased an Opel car in Jordan, the Palestinian agent is required to repair it if asked, even if they did not sell the vehicle. And that's mandatory language. The dealer shall do that. And then clause 4.5, the dealer is required, they shall use promotional material at its own expense for the sale of the motor vehicles, Opel parts and accessories in a reasonable quantity to be decided by Opel. So they are required at their own expense to market Opel in an amount decided by Opel. And the last sentence of 4.5 is that they are required to penetrate markets by segments based on a joint assessment. So Opel and Kema in this case are required to jointly assess how they're going to penetrate markets and segments and so on. Then while we're here, we should have a look at paragraph 4.11, clause 411, which Judge Quest considered important. Where it says this agreement does not make either party the agent or legal representative of the other for any purpose whatsoever. And the judge thought that that was a relevant clause in determining whether or not Kema is a commercial agent under the Palestinian law. And in my submission, which I'll develop later, he was wrong about that. And then turning to page 16, these clause 6.1.1.
Do we need to notice 412?
412.
Dealer is an independent business, solely responsible for success or profitability.
Yes. Yes, it's well that Opel wants to take no
Has no liability
liability.
in connection with the establishment of conduct of dealer operations. So responsible for all expenditures, liabilities and obligations.
Yes. Then
So it's an unusual principal agency relationship. Contains clauses like 411 and 412. I know you say 411 doesn't apply, and 412 is the obverse really. Making
Yes.
clear they're independent. It's another aspect of them not being an agent.
yes, well, I think Opel are doing what they can to avoid liability for anything. That is how I would interpret that. My lords, then I think we can move forward to page 16 and clause 6.1.1, where dealer acknowledges that Opel has established and maintains a network of dealers designed to provide customers with convenient locations and after sales. So in other words, that Kema is part of a network of Opel's doing its business. And Article 7 then sets out the dealer standards. That's on page 19. Article 7.1.2 provides that Opel will use the dealer standards as one of the criteria in appointing the network of dealers. The dealer standards describe the principles by which dealer operations will be conducted and in the manner that's constructive and positive for Opel and the Opel brand image, the Opel network and customers. So each of the individual dealers is required to conduct its operations in a way that is positive for Opel and its brand image and so on. And really the target I'm shooting at in some of these points is the assessment that your lordships will have to conduct at some point. Is this a merchant contract or a buyer-seller contract where we just buy vehicles and sell them? Or is it something somewhere higher on a spectrum? Is it some sort of broader relationship, indeed the commercial agency relationship that is the target I'm shooting at? What these clauses show is that it's not just a single transactional buy-sell relationship, it's more of a broader relationship. But let me keep going and I'll try and make that point good at the end. Clause 10.3 on page 23 deals with replacement parts. Dealer recognises that customers of motor vehicles may reasonably expect parts are Opel parts. Dealer recognises that the quality of parts sold on motor vehicles affects the performance, safety, durability and image of motor vehicles, affects customer satisfaction and affects the brand image of Opel, as well as the image of dealer. And then 10.6 deals with warranties and provides that the dealer is required to handle warranty claims. So 10.6.1, Opel warrants the cars and parts to customers as set forth in the warranties. And then about over the page 25, about 6 lines down, dealer shall directly handle and should be held liable for the claims of customers in relation to the warranty of vehicles, parts and accessories to customers. So the arrangement is that the dealer will deal with any warranty matters and then will seek reimbursement from Opel.
We also see in this clause another phrase, namely statutory law of the country of the area of responsibility. So we've got slightly different wording.
That's
and
true.
I think earlier on there was a clause you showed us which talked about local laws.
I think national law, that said.
No, local,
Oh,
local
okay.
laws in the dealer
Is
standards.
it 4 point?
7.1.1.
Oh, I'm sorry, okay.
Dealers comply with dealer standards unless not permitted under local.
Yes, I'm sorry.
So we've got a variety of different
Yes.
expressions. We've got local laws, we've got statutory law of the country of the area of responsibility, we've
Yes.
got national law.
Yes. So a variety of words which I think that those examples are clearly, it's clear what those ones mean, I would say, that they're referring to, in our case, the law of Palestine. But let's see what the one in question means. Yes. 10.8 provides that the dealer is required to carry out any inspections and corrections, you know, like when cars have issues across the board, the dealer is required to do that. And again, seek reimbursement from Opel. And then if we please could move forward a few pages to page 30, in clause 11.5, where Opel will provide training to the dealer in complying with dealer standards, and there's a minimum participation level in these training programs, and the dealer is required to contribute to the cost of the training programs. Clause 12.8. Opel may request dealer to transfer to Opel all information that dealer has in its possession concerning market conditions in the area of responsibility. Clause 13.1, I would draw attention to the dealer and Opel recognise that Opel is responsible for establishing a network of Opel dealers, and the performance of each Opel dealer affects the overall success and image of the entire network. So again, this is suggesting that each dealer is part of some wider Opel arrangement. And then clause 13.2, there is evaluation to ensure that the dealer is enhancing the image of the Opel brand. And then we need to look at Article 18, which is at page 39. So clause 18.1 provides that the agreement naturally expires on the 31st of March 2015. But it is common ground that it was continuously renewed by agreement between the parties on various occasions until it was due to expire on the 31st of December 2019. And then provision was given in clause Article 8.18.2 to terminate on notice. with a year's notice, and clause 18.3 to terminate for cause. And the judge found at the trial that contrary to Opel's case, there was no cause to give notice in this case. So the agreement came to an end by natural expiry. Liability on termination is set out in clause 19.1, which is obviously the key clause for this appeal. And that is on page 44, which provides that if the agreement is terminated under various articles for cause, the dealer shall have no right to compensation or indemnification resulting from the termination, but if the agreement is otherwise terminated, dealers shall have no right to compensation or indemnification from Opel resulting from termination unless otherwise expressly mandated by national law.
They're not quite all for cause, are they?
No, some, but not all. Yeah.
The first two are for breach. The next one, if Opel wants to reorganise, 18.3.4 is if there's terminates by agreement.
Yes.
18.3.7 is if there's a breach of trust.
Okay.
I'm not sure that affects your argument.
No. So, and obviously the words national law, there are the ones that are relevant to the current issue. And then just picking up a few more clauses before I address that question directly. Clause 22.1 on page 48 defines governing law, it's called, which is the laws of England and Wales. And then we have the annexes. If we turn to page, well, in fact, just for those, at page 51, this is the schedule which finally identifies the dealer. In this case, Kerish, at an address given in Ramallah, Palestine. Page 53, which is Annex 1, identifies at clause 1.1 the core location being an address in Ramallah, Palestine. On page 58, which is Annex 2, identifies the area of responsibility, which is given as the Palestinian National Authority areas. So those are the relevant clauses, and just addressing the first question then is what is the meaning of national law in clause 19.1, article 19.1. We say it's obvious in our submission that it means Palestinian law here for the following reasons. Firstly, the words national law in clause 19.1 are plainly distinct from the concept of governing law, which is defined in article 22.1. And by drafting clause 19.1 in that way, it appears to be deliberately worded to distinguish itself from the applicable or governing law of the contract. We would submit that it's obvious that this agreement is in standard form, where the specific party details are only set out in the annex. And one can infer that it is no doubt used by Opel for their contracts around the world with dealers in many countries. And they can simply insert the identity of the dealer and the area of responsibility in the relevant annex without adjusting the actual substance of the contract. And so the words national law are intended to reflect a law which varies according to the particular circumstances of each contract, rather than English law, which is, one assumes, fixed as the applicable law in all of Opel's contracts, wherever they may operate. I would also draw your lordship's attention to the clause I showed you at clause 3.1.10, which also uses this concept of national competition rules in that case. And as I said, because the wording was where applicable national competition rules, that clearly points to the fact that the word national is intended to have a different meaning in different countries.
You also expect if you say national competition rules in one place and national law in another, that in the particular contract in question, national has the same meaning, or it's pointing towards the same system of law, whether it's the general law or the competition rules.
Yes.
And putting it the other way around, if it was intended to be referring to the Competition Act, one would have expected it to have said so.
Yes, my lord. Yes, I would agree with that. And so I would also make the point that if clause 19.1, I think my learned friend's case is that the words national law mean English law or the governing law, but there would be no need for that clause if that was the case, because if compensation was mandated by English law, then because that's the governing law of the contract, it would be applicable irrespective of whether that particular clause was there or not. If it's mandated, then it's mandated. So there's what's sometimes called the argument against surplusage. But also, if it was intended to refer to the governing law, then it would just say governing law or indeed English law. Whereas by using national law, that only makes sense if that is a type of law that changes from place to place according to where the contract is being performed. It also makes perfect sense that the contract would provide for this, because Opel operates in many different countries. Some of those countries require agents to be compensated when an agency is terminated. No doubt Opel wishes to comply with the rules as they apply in that particular country for termination of agents, and therefore adopts that wording in its contract so as not to offend the local rules.
It all really boils down to the same point, doesn't it? That this is a standard form, use around the world. You don't know when you draft the contract, as opposed to the annexes, where it's going to be in force. This kind of standard form is very little reliant on the particular factual matrix to any particular use of it. That's a way of interpreting standard form contracts. It's only to be expected that the law of the country in which the particular use of the standard form is going to be affected will be respected. You're putting it in a lot of different ways, but that's the basic point.
Yes, you have my point. And the judge dealt with this in paragraphs 94 to 101 of his judgment, and we say respectfully that he was right, and for the reasons he set out. Lords, I don't know whether you wished me to carry on or wanted to hear from Mr. George on that question, or how to...
I think you carry on.
Carry on, yes. So I think then that's all I was going to say on that. We've dealt with the one voice issue, so we're on to issue 3 in my notes anyway, which is how should the English law approach foreign law issues? Assuming you're with me that means Palestinian law. So your lordships are going to be very familiar with this, and I'm not trying to break new ground at all. And it may be I'm just referring you to things you're familiar with, but let me show you the key authorities, and starting with Perry and Lopag, which is in the authorities bundle, tab 15, page 512. Which this is a decision of the Privy Council on appeal from the Court of Appeal in the Cayman Islands, and the very well-known section beginning in paragraph 10 to 15 is frequently cited as being a definitive analysis of this question now. And if we could just run briefly through the key points there.
Paragraph
10. So it's paragraphs 10 to 15.
Let's read that to ourselves.
I'm grateful. Yes, so my lords, I draw a number of points from that. Firstly, the proposition that foreign law findings are findings of fact, but of a particular or a peculiar kind. And then secondly, the proposition in paragraph 11 that the task for your lordships is to determine what the highest court would do in the relevant country. And then really what the other paragraphs go to is the point that's summed up in paragraph 15, that there is a spectrum of how your lordships approach this analysis, where on the one hand, one has common law systems which are very similar to English law in English, and on the other end, one has foreign law systems in a foreign language with very different cultures and not common law systems where the court is in more difficulty. But it's not to say that, and obviously we're towards that end of the spectrum, I accept that. But we're not completely at that end. We're not as far along as the court was in Byers, as in Saudi National Bank, as I'll come to in a moment. But we're somewhere on that spectrum. And the point is that at one end of the spectrum, the court is almost as in a gooder position as the first instance judge to do the exercise themselves, if it's a very similar English law system. But on the other end, the court still is not precluded from getting involved, but I have to show at the far end that the judge was clearly wrong or plainly wrong, and the court will be slow to intervene. I think those are the two guiding principles. When you're at the far end of the spectrum, the court is slow to intervene, and it must be shown that the judge was plainly wrong. But that doesn't mean never. It just means it's a harder task, and depending where you are on the other end of the spectrum, you're just in as good a position to argue it as in any appeal. So, and we, as I say, are somewhere between those points, as I will develop. So that is the proposition I take from that case, and we can see how the judges or courts have applied these principles in some other cases, in particular the preceding tab, in a case which actually Lord Justice Flaux was involved in that case, is the banker in Taser.
Do we need to see examples of the application of the principles rather than the establishment of any new principles? What are other cases going to tell us that Perry and Lope doesn't?
Well, what Bank in Taser showed...
Taser deals with one slightly different point of paragraph 152, doesn't it?
Yes.
The distinction is drawn there.
Yes, exactly.
Between what the Italian law was,
yes,
on the one hand, and the application of the Italian law to the facts by Mr. Justice Foxton in that case.
Exactly. So that's what one draws out of that case, which I don't think came out of Perry and Lowe. Exactly, which is that so the court can feel much freer to consider whether the foreign law was applied correctly, even if it's a law they're not familiar with. That's very different from identifying the actual law, where those principles do apply. And yes, and as your lordship says, it's exactly in paragraphs 151 and 152 where the court made those submissions.
153 is important as well, because 153, the points made that still in an evaluative exercise.
Yes.
In relation to the facts, and the court will interfere satisfying the
Yes. Yes, I would accept that as well. Yes. Yes, and can I just also refer to paragraph 66 of Banker in Taser, where counsel made 2 points.
Which paragraph?
Paragraph 66. So Ms. Delaney made 2 points. The first was that where a case lies on the spectrum, which is the spectrum in Perry and Lopag, which I was showing your lordships, where a case lies on the spectrum does not depend on a bright line distinction between common law and civil law. What matters is the content of the foreign law and whether the judge can bring his or her legal judgment to bear on the question. And then the second submission she made is the one that we just talked about, and which is made at paragraph 67. There's more room for the exercise of legal judgment when it comes to applying the law.
But the court in Banco Tesa didn't actually adopt that. And she may or may not have been right about that, but what was found at paragraph 150 is that the various principles of Italian law that were in issue were unfamiliar ones which required expert evidence from the Italian lawyers. So it wasn't I mean, what she's talking about there is a sort of halfway house where there are some,
Yes.
in some civil law systems, there are concepts which are not dissimilar to or are the same as
Yes.
English law concepts. And you can quite see how in those circumstances an English court could bring to bear its own judicial knowledge in assessing the foreign law, but in this case, the foreign law was all unfamiliar civil law.
Yes, but I think the point she was making that I would adopt is it's not just a very simple case. Is it common law? Is it not? It's the court says what is the legal analysis that is required in this particular case, and how foreign is it to my own skills and knowledge and experience? So it's a more nuanced approach, and so one doesn't just say, oh, Palestinian law is terribly different to English law. This court can't possibly grapple with it. One actually says, well, can we grapple with this particular question that we are faced with as the court? And then just pick up buyers, which I guess is probably worth looking at, given that it has given that it was an Arabic legal system, and my lord Justice Popplewell was involved. It is tab 12. That was an appeal from a decision of Mr. Justice Fancourt, where there had been an extraordinary amount of expert evidence that he had dealt with, which we see from paragraph 82 of the bundle. Paragraph 82, the judgment at tab 12, page 412. Where Mr. Justice Fancourt had dealt with the Saudi law issues in a careful and detailed section of the judgment running to 88 paragraphs. And paragraph 94 of this judgment says that there were reports from the experts ran to 300 pages with 2,500 pages of exhibits and numerous Saudi cases and materials. The experts were cross-examined for 2 days, during which the judge also asked questions from time to time. And the Court of Appeal addressed the question of how foreign law should be dealt with from paragraph 98. This was obviously before Perry and Lopag. But it sets out the similar principles. And really, if we can turn, please, to page 41, right at the bottom, 415, the court referred to, in the last sentence, it says, Lord Justice Evans had given a judgment in Macmillan and Bishopsgate, which was then cited paragraphs 416, page 416, sorry, and in the last sentence of that citation, the judge in that case had said, when and to the extent that the issue calls for the exercise of legal judgment by reference to principles and legal concepts which are familiar to English lawyer, the court is as well placed as the trial judge to form its own independent view. And at paragraph 104, the Court of Appeal said that Mr. Chapman had relied on that.
It's the same passage as we cited in
Very low.
Anchor and Taser.
Yes. And Mr. Counsel had relied on that passage to submit that the court was as well placed as the judge to decide what a particular article of the capital markets regulation meant, because there was no issues as to Saudi Arabian principles of construction. And that proposition was rejected by the Court of Appeal, where it says where the foreign law is in the form of a provision in a code, statute, or other written sort, the task of the court remains one of determining how the foreign courts would interpret it, based on the evidence of the expert witnesses. Generally speaking, the court's task is not to address how it would itself interpret and apply the provision. The wording in the provision is to be considered only as part of the evidence and as a help to decide between conflicting expert testimony. And then there was a qualification identified by the Court of Appeal where it's very similar to English law principles. But at paragraph 105, they say there's no scope for applying that qualification to the general principles. In this case, the only authorised texts are in Arabic. They were using a translation. It's an Islamic system of law whose concepts and principles are far removed from the common law familiar to English judges. It was an unfamiliar system of law against the background and practice and culture in the capital markets in Saudi Arabia. There were moreover numerous Saudi Arabian court decisions prayed in aid by both experts in support of their contentions. There was extensive expert evidence, etc. Etc. Your Lordship can see what was said there. So in that case, the Court of Appeal said that they were not willing to embark on any sort of exercise of applying their own knowledge and skills. But we would submit that we are not quite at that extreme here, because this is not a case where there were numerous Palestinian cases addressing this particular provision. There was one case which didn't really assist because it was dealing with a sub-agency.
Palestinian law is based on Jordanian law, at least
Yes,
to some extent.
some connection with Jordanian law, that's true.
The word Jordanian.
There were plenty of Jordanian cases, that's right, but as I'll try and show your Lordships, they don't really assist because they are looking at a statute worded in a different way, and that was one of the ways the judge went wrong.
So the evidence was that Palestinian courts look to Jordanian cases for guidance where there is a lacuna in the Palestinian cases. That was the evidence the judge accepted.
Yes. Yes, but true, but one doesn't just read them across, as in the judge simply read them as if they were applicable, I would say, in circumstances where, in fact, on analysis, they are of no assistance because
Well, that would be applying the independent analysis, wouldn't it, rather than what the judge found on the evidence. Judge found on the evidence, as I understand it, Palestinian courts look to Jordanian cases for guidance, and therefore it was legitimate for him to consider Jordanian cases.
He found that where there was a lacuna.
I think that's what I just said.
Yeah, I'm sorry. Yes, that is what he found. But the situation, in fact, we have is that there is a Palestinian statute in different words to in materially different words, the Jordanian statute. We have a Palestinian authority, the Court of Cassation level, dealing with the Palestinian case. And in my submission, the judge went wrong by applying across a variety of
If the
Jordanian.
Palestinian Court of Cassation case doesn't address the specific issue that arises under the agreement, which is essentially what the judge says.
We said yes, it doesn't.
And what is wrong with the judge looking by analogy? But albeit recognising that they're not on all fours because, for example, the facts are all slightly different. But the general principles.
Well, yes, I accept that the judge found that where there is a lacuna, he's entitled to look at Jordanian law. But in our submission, there was no lacuna. And even if there was, he applied Jordanian law wrongly. It was plainly wrong. What he said was plainly wrong, as I will attempt to explain and persuade your lordships.
Right.
In my submission, the buyer's case is at very far end of an extreme, where there were numerous Saudi cases, 2 days of expert evidence. I can't remember, thousands of pages of material, whereas we don't have any of that here. We had much.
The expert evidence
I think it was a day, but would you agree with that? A day. A day. Yeah. There were not thousands of. We have the entire corpus of material that we had. So it was hundreds of pages of Jordanian authorities and tens of pages of Palestinian authorities. And the task, as I will try and show your lordships, the task doesn't require getting into Palestinian cultural issues and capital market, the complicated issues of capital markets. It involves effectively a question of statutory interpretation of a statute. What does that statute mean? Which is, in itself, that's a very familiar exercise for your lordships. Obviously, it's in translation. I also accept that there was a difference between the experts as to the proper translation, but the judge found that didn't make a difference.
In Ives, Justice Lee said it would have been wrong in principle. The judge took the task as one of interpreting the provisions for himself as a matter of construction. Does that also apply to our case?
Well, I'd say no, because I'd say that was in the context of where they had thousands of pages, many Saudi cases bearing on that very question.
The issue for the judge in this case was, insofar as it was a question of construction, to consider what was meant by a provision that was not in English and over which there was a dispute as to the proper translation.
Yes.
But the judge sensibly, properly approached the issue of construction for himself.
His task,
matter of what he thought the English words meant.
Well, his task was to use all the evidence before him, which included the text of which is what it says in bias, that one is entitled to look at the code and also the expert evidence and to be assisted by the experts in what they say and to come to his view as to what a Palestinian court would have found. But in doing so, he doesn't leave behind his own knowledge of how to interpret statutes. He applies that in the context of all the material before him. And so it's not a bright line. I think that's what the point on the spectrum is. There's no, the judge doesn't delegate his decision-making to the experts. He has to form his decision on how to interpret all of the evidence, which includes the experts and is very much guided by the experts, but at the end of the day, it's his decision.
That doesn't seem to be what the court said in Byers, because paragraph 104,
yes,
the judgment of the court says the court's task is not to address how it would itself interpret and apply the provision, and then this part, the wording of the provision is to be considered only as part of the evidence and as a help to decide between conflicting expert testimony. So that's the function of the text, according to this.
No, well, I accept that. Although, I would say it says generally speaking, but let's ignore the generally speaking. But what that suggests is the task for the court is to look at the wording in the statute and use that to use the actual wording to help decide between what the experts say, is what it says. So in our case, we have Dr. Husseini says the meaning of the statute is we are a commercial agent. Mr. Atteri says the meaning of the statute is we're not a commercial agent. And what the judge does is he looks at the statute as what it says as a way of deciding who he thinks is correct. But which, in other words, he has to look at the statute and apply his judicial mind to the statute, but as a way of deciding between whose case or which expert he believes.
Yeah.
So I'm not sure it's very. It's probably it's too. It's a sort of organic process, isn't it? It's not.
What it's not saying is and I think the point that's being made, as I understand it, and the same point my lord just put to you, but it's not saying the judge looks at the wording of the statute, decides what he thinks it means, he or she thinks it means, and then sees which expert accords with that view.
No.
It's what it's making clear is the judge is looking at the statute and interpreting its meaning according to what the experts have said it means. So if you've got one expert who says it means X and another expert who says it means Y,
Yes.
the judge has to choose between X and Y, because they're the experts of foreign law.
Yes.
What he can't do is say, well, never mind what they say, as it were in his own head.
Yes.
Say, well, never mind what they say, I'm going to find it means Z.
No. But he I think so. Yes. But he looks at the statute and says, well, someone says it's X, someone says it's Y. Looking at the statute, to me, it means X, and I agree with the person who says X. But it still is a process of looking at the statute and seeing whether it's X, isn't it? Rather than just looking at the witness statements of the experts and saying, oh, well, that's a very good statement, and that one's not very persuasive, so I'll go with that one. Shall I keep going? 5 more minutes, yeah. So all I trying to say is that there is a spectrum for this court. On appeal, there is a spectrum, and Byers is probably at the far end of the spectrum, where the court really can't, or finds it very hard to form its own view. And we are, I agree, approaching Byers, but we're not exactly there. My task is slightly easier.
Essentially, the question for the judge is not what, assisted by the experts, do I think it means. It is what evidence do I accept from the experts as to what the highest court in Palestine would determine so means. Is that the right way of looking at it?
Sorry, for the trial judge, yes. The question is, this expert says that the highest court will say X. I think that's what the way it is. Well, maybe not. Maybe one expert says it means X. The other expert.
It's not what the judge thinks it means.
No, it's not
It's what the judge accepts by way of evidence from the experts as to what the experts say that the highest court in Palestine would decide it meant. Is that right?
Yes.
The expert evidence should be addressed to the issue. What has the highest court in Palestine decided about this provision, if it has?
Yes.
Or if it hasn't, what
Yes.
in the view of the experts would it decide?
Yes.
And then the judge has to decide which of those experts he accepts.
But by looking at the statute, say, himself, and saying, well, reading this statute, using my judicial brain, I'm more, that expert seems right to me, and that one is wrong.
So that when you take us to the wording of the Jordanian provisions and so on, that has to be in support of a submission that because of what they say, the judge was plainly wrong to accept Mr. Atera's evidence.
Yes.
That's the exercise that you're embarking on, is that right?
Well, I think if I'm at the far end of the spectrum, if your lordships think this is equivalent to Byers, then I have to show he's plainly wrong. But it depends where I am on the spectrum as to how wrong he has to be. But broadly speaking, I have to say the judge got it wrong. That's right.
It's got what wrong?
The analysis that we were just discussing wrong.
I.e. his acceptance of Mr. Atera's evidence.
Yes, exactly.
That's what he got wrong.
Yes.
Yeah.
I see we're at a moment, maybe.
Right. Well, all right. Well, you're going on to another point, presumably.
Well, I finished with Byers, yes.
Yeah. Do we need more authority on this question?
Maybe one or two cases, but I'll look at my notes.
Well, I hope that if you're going to cite more authority, they're going to tell us something we don't already know. 2 o'clock.
All rise if able.